of August. Well, we're a little over 10:30. First of all, I'd just like to introduce ourselves on the top table so you know who's speaking and who's in what part. Mike, if you would like to.
I'm Ryan Hudgins. I'm the legal advisor to the licensing subcommittee today.
Thank you. I'm Megan Barrow. I am District Council and Parish Council here in Codsall and Chair this morning.
I'm Rita Heseltine. I'm District and Parish Councillor for Purton Lakeside, Cabinet Member for Regulatory Services and Deputy Leader.
John Shisley, Licensing Officer.
Morning, Lee Jameson. I'm the Assistant Team Manager for Environmental Health and Licensing.
Thank you all. I'd just like to let you know this meeting is being recorded. Chairman, I am sure, so we've already gone through that procedure, and apologies. Declarations of interest from anyone? No, we're okay on the committee. Thank you. And the premises licence hearing procedure. This meeting this morning will be divided into two sections. Obviously, the first one will be to discuss the procedures of how it was advertised, etc., and whether they all met the appropriate procedures. So we'll deal with those issues first, and then we will discuss those issues. We will ask the members to leave the chamber while we discuss those issues before we move on further. So if we'd like to go to the premises hearing procedures first, please. John, who's going to, Lee, are you going to do? Thank you. Just before Lee starts, I will just say the first part of the proceedings will be, you've all had an opportunity to read the paperwork on pages 1, 2 and 3. Thanks, Lee. Over to you.
Thank you, Chair. This is an application for a grant of a new premises licence that was received from Passingham Vineyard via the gov.uk portal on the 17th of June this year. It was forwarded to the other responsible authorities and displayed and was advertised in accordance with the requirements of the Act. The application is attached as Appendix A, pages 15 to 36 of the report. The premises are situated at the bottom of Great Moor Road, where it meets Moor Lane and Bennett's Lane. The application relates to the house, barn and 8 acres of vineyard. A site plan of the site is appended to the application too. The application, in its original format, was for the following licensable activities and times: the provision of live music, which wasn't specified if it was indoors or outdoors, Monday to Sunday, 12 noon to 9 p.m. The supply of alcohol, Monday to Sunday, 9 a.m. till 9 p.m. None of the responsible authorities have made representation against the grant of a new premises licence. Staffordshire Police have agreed a number of conditions with Passingham Vineyard, and should a new premises licence be granted, the agreed conditions can be found at paragraph 4.6 on page 7 of the agenda. And the brief synopsis of the conditions are regarding CCTV and Challenge 25 and training. Representations have been received from 10 local residents who live in Great Moor Road, and these were received by the licensing authority between Monday the 11th of July and Friday the 15th of July this year. The grounds of representations objectives are the prevention of public nuisance and public safety. The objection letters are attached to the committee report at Appendix B, page 37 to 63. The applicant and DPS, Ms Stephanie Wilcox, on Thursday, the 14th of July, that there are a number of objections, and the objections were emailed to her on Friday, the 15th of July. With the objections, letters and emails were provided. Photographs of Great Moor Road and the junction of Moor Lane, Bennett's Lane are attached as Appendix C, pages 65 to 72. And there's also a Google Street View plan of the area attached as Appendix D, page 73, and that shows the location of the vineyard and also where the photos were taken. On the 15th of July, the applicant had submitted to the licensing authority two court appeal judgment, which is a Word document, and an article regarding the vineyard, which was objected to sell wine, to do wine tours, etc., by local residents. The vineyard was situated on a rural single track. An enforcement notice was issued to the proprietor that was appealed, and that's how the judgment of Millington came around. And these documents are attached as Appendix C, page 75 to 100. On Tuesday, the 26th of July this year, an agent who's representing the applicant emailed to the licensing authority a revised operating schedule, which included new times for licensable activities to take place. The email was sent to all the objectors, and the revised application is attached as Appendix F in the supplementary to the agenda report. So following the email and the amendment, the application now stands as the removal of any request for regulated entertainment for live and recorded music. Off sales by telephone and internet with home delivery facilities, Monday to Sunday, 9 a.m. till 9 p.m. On and off sales on site via Connoisseur Vineyard Experience Friday, Saturday and Sundays from May to October annually, with the premises open to the public 9 till 5 Monday to Sunday. Seasonal variation of 9 till 7 p.m. Friday, Saturday and Sundays from May to October annually. See the Connoisseur Vineyard Experience tours above. The business model for Connoisseur Vineyard Experience tours is a day with 2-hour duration, booking by appointment only for parties of tour parties of 6, but no more than 12 persons at any one. No party arrive or be collected to and from the site by passenger service vehicles. Wine tasting events to comply with the Portland Group guidelines for product sampling. That's the attached, and that's in the bundle as well. And then they've also listed a series of revised conditions. And that concludes the report.
Thank you for that, John. There are 3 issues to be discussed in the first part of this debate this morning. Is there a defect? If so, does it contravene regulations? Now starts. Over to you.
Okay, good morning. My name is Nick Semper and I'm a licensing consultant, and I've been asked to represent Passingham Vineyard in this matter. Now, this has very much come as a surprise to us this morning, this defect, this issue, and we're very grateful to gentlemen opposite apprising us.
Mr. Semper, sorry to interrupt you. Perhaps it might be better if the objectors could state what their objections are with regards to the procedure or deficiencies they state, and then you'll have a better understanding of what they are to respond.
Fine.
If you're agreeable with that, Chair.
Absolutely fine by me, sir.
If we hand over to Mr. Evans at this point, who represents, I believe, 8 objectors this morning, outlining arguments with regards to any procedural defects the objectors say may exist.
Yay, found one.
Okay, there we go. Thank you. I represent 8 local residents who put in representations. There were other people who wanted to put in representations who missed the deadline. And I can't speak on their behalf this morning because they were too late. I invite you, the residents invite you, to conclude that the application itself is defective in its entirety this morning. There are 2 grounds for that. The first ground or argument relates to the application and the application form itself. And the point is this, that where an application for a premises licence is made by a partnership, there is a mandatory requirement on the face of the form itself and within the regulations for all the members of the partnership to first be named and second to have signed the application form. If we start with the Licence Act 2003, Section 17 of that Act provides that an application for a premises licence is subject to any regulations that were made under Section 54 as to its form, the manner in which it is to be made or given, and the documents that must accompany it. The regulations that were issued are the Licensing Act 2003, Premises Licence and Club Premises Certificates Regulations 2005. Regulation 10 of those regulations states that an application shall be submitted on the prescribed form, and the regulation reproduces the form that you've got, the form that everybody uses, and shall contain the information set out in Schedule 2. Now, if I can take you to the, if you could look at the first page of the application that's before you. You can see at the bottom of the first page that the box has been to say that a person other than an individual is making the application. B2, as a partnership, tick. What's the next instruction? Please complete section B. If you go on to the second page, this isn't then an individual. So that box has correctly been left blank. The applicant has indeed moved to be other applicants on the third page. The instructions state, please provide the name and the registered address of the applicant in full. Where appropriate, please give any registered number. In the case of a partnership, that's this application, or other joint venture, other than a body corporate, and the applicant is not a body corporate, please give the name and address of each party. What should have happened was that each of the partnership should have given their details under other applicants. If the application is made in the name of a partnership, state in mandatory terms says on the face of the form that the names and contact details, addresses, and then at the end, if you go to the very end, it has to be signed by everybody. It's also got to be signed by them. Page. That's the penultimate page where there are the boxes underneath Part 4 signatures. For joint applications, signature of second applicant or second applicant solicitor, etc. It may be that there's more, but it has to be signed not just by one partner, but by all of them. So on the face of it, this application's been signed by one of the four partners, and the identity of one of the four partners has been put on the form. So as it was put to me by the residents, at best, it's only 25% compliant with the regulations. So in respect of a mandatory requirement framed in the regulations on the face of the form, there is very clearly a defect in the application. But the next question is, why does it matter? It matters because the starting point for any application is who is actually making it. Now, there is a danger with they may be loose, and we say that it's imperative that the licensing authority and anyone who might have the opportunity to scrutinise the application knows who it is who is asking for it, knows who it is who will hold the licence and be trusted with it if the application is granted. So the identity of the licence holder is very important at the outset. And that's probably why the regulations are there and why the form's set out in the way that it is. So the problem or mischief here is that it follows that when the application was made, none of the responsible authorities had the proper info for them, and anyone else who might have wanted to inspect the application or did in fact inspect it had arbitrary information as to the identity of the partnership. So no one who was busted or nobody who actually did make a representation, or those who wanted to, did so or took steps or didn't take steps in respect of a compliant application. And of course, it's not something that can be cured after the event, because what happened next in the process was the consultation period, and the consultation period is now passed. So even if, as we know, the names of the partners were later offered, those people who wanted to make representations, but who can't now because the representation period has passed, they can't be armed with the information after the event. So for them, it can't be fixed. Once the consultation period is ended for responsible authorities and for other potentially interested parties, members of the public, it's too late. So we say that it's effective application for that reason alone, and the residents can't see how it now can be corrected or glossed over. So if broadly there's a test that you have to look at the justice of the situation, we say that it would be wrong for you to permit this application to proceed. Before I go on to the second ground, if I just set out what we say is the legal framework for the decision that you have to make. It is abundantly clear, certainly in respect of the first ground, but we'll go on to say why in respect of the second ground, that mandatory requirements have not been met. The language in the regulation is mandatory, shall means you have to do it. Everybody knows that. But if there are errors or omissions in an application or in the application process, you as a licensing committee have a discretion as to whether or not to grant a licence, notwithstanding those errors. And every case where this issue arises turns on its own facts and circumstances, because no two cases will be exactly the same. But ultimately, you have to decide how serious the errors were, whether individual or cumulative, adding them together. But we say that if you decide in the end that the defects that we point out are trivial and that there's been substantial compliance, that no one's been misled or suffered any real prejudice as a consequence of them, then you may grant the licence. And we can all think of situations in which that would be obvious, where perhaps there's a mistaken name, a misspelling, something that's alluded to that could have been set out with a greater degree of detail, but some minor defect that really in the big picture of things doesn't matter and couldn't matter at all. But if on the other hand you think that the defect or defects are material, that's real prejudice to the process or to people who may have wanted it, then we say you shouldn't grant the licence. And in saying that, I think that we would say overlaps with how, Chair, you put it as 3 bullet points in a shorter format beginning of the hearing. But on to the second ground, the notice. We did wonder whether it had been published in a local paper, but we've seen that now. We found a copy of it this morning, so it was advertised in a local publication. But I want to tell you about the blue notices. The first point is how many were put up and where they were put up. There are various images, but the one that I'd like you to look at first is the plan of the original application with the red line drawn around the field. Forgive me, I don't have the page number to hand because I've got my papers in a different format. 34, page 34, thank you. Now, what the blue notices should look like and where they ought to be put is also in the regulations at Regulation 25. And I know that Mr. Hodgins will have a copy of this and be able to show it to you later when you deliberate. But the requirements are this, that it has to be up for no less than 28 consecutive days. It has to be a certain size with a certain font in a certain pale blue colour. But Regulation 25A2 states this: in all cases, prominently at or on the premises to which the application relates, where it can be conveniently read from the exterior of the premises, and in the case of a premises covering an area of more than 50 metres square, a further notice in the same form and subject to the same every 50 metres along the external perimeter of the premises abutting any highway. And there hasn't been here, we say, compliance with on the plan on page 34, it's the short boundary on the edge where the field narrows or the land narrows that abuts the public highway. And that distance along the public highway appears to be in excess of 100 metres. There are some photographs as well that help. If you look at photograph H in Appendix C, you have a view along the lane. And on the right of that, where the blue entrance to the vineyard, but that's that on the right, sorry, where the fencing is. On the right of that image, you see the long boundary of the applicant premises where it abuts the highway, albeit the highway is just this lane.
Sorry to interrupt you, Mr.
Yeah.
Evans. I'll just help the chair find the relevant
Yeah,
page.
sorry. Would have helped if I had the page number.
Page 72.
Page 72. Sorry.
Thank you, Mr. Evans.
So there we are, looking along that boundary of the applicant premises where it abuts the highway. That is more, we say, than 100 metres. There is also a photograph, which is, if you go back a few pages, photograph B, the entrance to the Pattingham Vineyard, page 66. If you focus and zoom in, I can do that easier on my screen than you can with the hard copy, but you can just see the single blue notice into the construction site, attached to the outer edge of the third sort of rack of metal fencing. Behind it, there's the digger, or what looks like a digger. So this grumble proceeds against the background of there having been, as you know, late objections or late representations that you're not entitled to consider. You are, in the other residents' development, entitled to consider the fact that there were people who wanted to make representations but couldn't. If we focus first on the blue notice that we can see, it is not, and it cannot be, conveniently read from the exterior of the premises. To get to it, to notice it, and then to see what it says, somebody passing would have to depart from the public highway and move a good number of metres towards the entrance of what appears to be a construction site with other signs warning about different things, or advertising different things in order to see it. So we say on the face of it, that requirement has not been met at all, convenient or prominently displayed. The second point, though, is that because there is a boundary because quite obviously the application went in, were more than 50 square metres, it was a huge area of land, that there has to be a further notice in the same form every 50 metres along the external perimeter of the premises abutting any highway. So there should have been at least one, if not two, further notices. Because if you think about it, you would only need a boundary of 51 metres or 50 metres for their requirement to be two notices on that boundary. Because every time you come to 50 metres, there's a requirement for another to be displayed. Why? Well, if you've got a big boundary and it's for a big premises, you need to improve the opportunity of passers-by to become aware of that application. That's what that regulation gets at. So there's a second set of reasons why this application is defective. It has not met, again, the mandatory language of the regulation. Why does it matter? Because it will have significantly reduced the opportunity of local residents to see, become aware of, and put their representations in in respect of the application. So that's a very clear mischief. There is another small point about the blue notice, and that's that, and of the three, this is by far the least significant. In terms of what it stated, it said that the application was for the supply of alcohol and for live music. It doesn't much matter now, we accept, that it stated live music, even though live music itself isn't a licensable activity, because that part of the application's fallen away, as we know and understand. But in respect of the supply of alcohol, the licensable activity is the retail supply of alcohol. And that does make a difference in the context of a vineyard, because as the partnership now tell us, one of the aspects to the licensable activity that they wish to carry out through this application, they've produced the Portman guidance about that. But that demonstrates that there's a difference between retail sales and other supplies. What wouldn't have been obvious from this form was that there was an intention to carry out the sort of commercial on and off sales from the premises that is now pursued. So again, it's a small, in the grand scheme of the arguments that we put forward, it's the smallest of the 3 points. But again, the blue notice itself there was defective. They didn't actually fairly set out what they wanted to do. Why does it matter? Because there's a difference between significantly commercial and less commercial activities, or less risky activities. So for those reasons, we say when you apply the law and exercise your discretion properly, this is an application, I'm afraid, to be rejected as non-compliant, as having caused substantial prejudice or risk of prejudice to people who may have wished to have made representations, and it should be stopped at this stage.
Thank you, Mr. Evans. Does the
One question, please. You mentioned right at the very beginning that there were people that you cannot represent because they were late making
Yes.
their objections. Do you know how many people?
Yes. And we can always, if necessary, solve it with a show of hands. I think it's about 12. About 12 people, I think, from at least 7 or 8 households. 12 people from 7 or 8 households.
From 7 or 8
Households, yes.
Okay, thank you.
Mr. Semper, do you have any questions for Mr. Evans at this stage? No. Hand over to you then to make your representations on those points.
Good morning, everybody. Again, my name is Nick Semper. I'm from the licensing guys, and I'm representing the vineyard this morning. Thank you very much indeed, Mr. Evans. Completely understand the point you've made. And now the blue notice was placed at the entrance as my clients believe as directed by the licensing officer. We were unaware of any issues, in fact, to do with the blue notices or indeed the alleged suspected shortcomings of these forms until this morning. Now, dealing with the partnership details first, yes, technically, maybe every member of that partnership should have signed that initial form. However, you'll also see in your bundles that I wrote to you and indeed to all the representatives via the Goodley Licensing Authority on the 30th of July, when we clearly stated the 4 people that make up the partnership: Martin Wilcox, Jane Wilcox, Stevie Wilcox, and Daniel Wilcox, who are not here. I don't think this probably came as a big surprise to anybody in the area, because this family have been running this vineyard since 2018, and I believe that would have been clearly evident. And whether that slight defect in the submission is fatal, I'm not convinced. Secondly, on the blue notice, yes, but there was but one blue notice put up, and the applicants believed they were acting in accordance with the advice they got from the licensing officer in the case. And maybe, yes, indeed, on the strict application, there should have been 2 more blue notices, one 50 metres further up the lane and another at 100 metres up the lane, if that is the distance. Okay. However, the newspaper notice was indeed correctly placed. Clearly, people were aware in the location because there were a number of representations against. The applicant has communicated with neighbours throughout the consultation period via email and certainly the representatives via the kind auspices of the licensing authority have received 2 further emails from us during that period from when we were instructed at the end of the consultation period to today, setting out the application. I would venture to suggest that the absence of the 2 blue notices in the lane are not fatal, because you'll notice in your bundle, I'm not sure what page it's on, but we have supplied a new plan. And it is a much reduced plan. You must forgive Stevie, who completed the original application. She's not an expert in law. She's taken advice and acted upon it. Now, if that advice or those actions have failed to meet the precise letter of the regulations, so be it. But realising that the original plan submitted was far too broad, we have supplied an aerial view with the plan on, and there we have the red bit, which is the licensable area, and the blue at the barn at the top. Have we got that, guys? Okay. And the blue bit, which is the consumption area. You'll notice none of that, as it currently stands, bounds that perimeter and that lane. Okay. Indeed, amended our application down to being a fraction of what it formerly was. And albeit we accept that there have been some shortcomings here, so as to prove the proceedings this morning to in the light that that original application has shrunk so much down to where it currently is, and has been explained to such an extent by our emails, the licensing guys' emails of the 26th, 27th of July and the 30th, which are the final 2 appendices in your bundles. And therefore, we'd ask you, please, that you allow this, you recognise these shortcomings not to be so fatal that we cannot deal with these matters today, and proceed to the second part of the hearing, and that's where we are. Thank you very much indeed. Thank you.
Questions for Mr. Semper at this point on the bench? Mr. Evans, do you wish to ask any questions? Grateful. At this point, then, it may be appropriate for the bench to retire to consider their decision on the first point that's been raised this morning. I will see them during that time and ask everybody else to leave the room. Any legal advice that I give them, I'll announce when they return with their decision.